Okay, so yeah, we're live on YouTube now. Um, this is the actual appeal brief that I filed, and so this is a total of. There's an appendix too, but this is just the brief, and the appendix is like about 500 pages. It cost me $900 to make copies and get it ready, and that was the cheapest estimate that I could find. There was some that were like in wanting $3,500. Anyways, and they didn't even do it right. It's supposed to have the appeal brief is done right, but the appendix wasn't done right. The appeal brief cost me $300 to make copies. I'd make 27 copies, and the appendix was 494 pages, and that one cost me $900. Anyways, so there's the corporate disclosure statement. The appellant fails to be a corporate slave of any kind, including the Pope's slave property, minor estate, fiction called a U.S. citizen, and the appellant has lost a first-hand knowledge of how the Pope's private bar guild scum intend to presume the appellant's dead and lost at sea, in spite of the fact the appellant says he's living in every document he's filed everywhere, including document 113, affidavit of life, filed on May 30th, 2025. The only things that might interested in this case are as follows, and these are all the liars. Opposition to oral argument. Appellant's not one of the Pope's private bar guild liars. Although appellant has attempted to become acquainted with the relevant law, and as much as appellant's not one of the Pope's private bar guild liars, it would be patently unfair to pit the appellant against the Pope's private bar guild liars in oral argument. Therefore, in the interest of fundamental fairness, appellant moves the court to make all rulings based on the pleadings before the court. Should the court determine oral argument in the instant matter will aid the resolution of the matter, in order to avoid surprise, appellant moves the court to direct the Pope's private bar guild liars to give prior notice of all law and case law it intends to bring before the court in oral argument. So then they require a table of contents and a table of authorities, and so that's what this is. And then, so this is really the beginning of the document on page 5. I'm limited to 30 pages. And so this document's actually 36 pages, but as you can see, and that's not including the certificate of service either. So, and the certificate of service was 2 pages. So it's under 30 pages. So this action in the lower court was initiated because a federal question, your code of law for the District of Columbia, Title 28, USC, Section 1331, federal question, because taxation of land originated with an act of Congress under Chapter 45, approved August 5th, 1861 at 12 Stat 292, that has not been repealed or modified, and that provided for 1. Tax assessors and collectors at Section 9 at 12 Stat 296. They're required to execute a bond at Section 10 at 12 Stat 296. They have an oath of office at Section 11 at 12 Stat 297. The Secretary of the Treasury to provide regulations at Section 12, 12 Stat 297. Direct tax on lands and lots of ground at Section 13 at 12 Stat 297. A Board of Assessors at Section 25 at 12 Stat 300. Tax liens at Section 33 at 12 Stat 303. And every collector that shall exercise or be guilty of any extortion or oppression under color of this act shall be liable at Section 43 at 12 Stat 307. And a penalty for taking false oath, perjury of oath at Section 47 at 12 Stat 308. and there shall be allowed in full compensation for their services at commission. They get a piece of the action. They're a bunch of fucking thieves. Section 48, 12 Stat 308. By the way, I find it interesting that I sued the Texas comptroller, and they now have an acting comptroller. So, and he's a bar member scum, and this ain't fucking over by a long shot. Anyways, don't get me going. And there shall be allowed in full compensation for their services a commission at 12 Stat, Section 48, 12 Stat 308. Diversity of citizenship, your code of law for the District of Columbia at 28 U.S.C. 1332, because all appellees are the Pope's 14th Amendment U.S. citizens as required by Texas civil codes under the Commerce Clause, and the appellant fails to be the Pope's 14th Amendment U.S. citizen slave property as described herein, and Congress has exclusive legislative jurisdiction of the Pope's 14th Amendment U.S. citizens under the Commerce Clause. So we therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3. In other words, cases between the citizens of the district and those of the states were not included in the catalog of controversies over which Congress can give jurisdiction of the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens even when in one of several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. Unalienable rights, civil rights, under your Code of Law for the District of Columbia, Title 28 U.S.C. 1343, because appellees are stealing the appellant's land and the appellant has an unlimited natural right to own land. Forfeiture, under your Code of Law for the District of Columbia, Title 28 U.S.C. 1355, because appellees are stealing the appellant's land. Mandamus, under your Code of Law for the District of Columbia, Title 28 U.S.C. 1361, petition for a writ of mandamus to order Chad Yarbrough's successor to do his duty to arrest the appellants for their felonies, and Leah Simonton or her successor to do her duty to prosecute the felonies, since they refused to do anything about it, because appellees named herein are engaged in multiple felonies, as evidenced by the 78 criminal complaints filed into the Texas 97th District Court, also filed into the lower court, which the Pope's clergy unfiled. You notice the clergy, eh? Because the bail priest is the clergy. And I'm not saying it. Their law dictionaries are saying it. The Pope's clergy in the lower court enter final judgment on 21 February 2025. Notice of appeal is filed on 3rd of March 2025 within the 60-day time requirement. Court of Appeals is the proper venue to get a void judgment vacated. Issues presented for review: the minor states, fictional law which originated with the Pope, and canon law, and the legislative usurpation of the bench, which is a bill of attainder and unconstitutional. The Pope's owned and operated 1871 Municipal Corporation, the National Bar Foundation, and the Pope's Private Bar Guild State Bar of Texas are all unconstitutional. So the facts: on 27 September 2021, the appellant converted silver to land in Texas and stated on the bill of exchange, and so ROA means record on appeal, and that's the pages in the appendix where this can be found, that the appellant failed to be assessed to trust. Let me go and look at YouTube. Well, there's a couple people there. Okay. Shows that there's 6 viewers right now. The Pope's owned and operated appellees and the Pope's Private Bar Guild members converted the Texas land to the Pope's Foreign United States, Inc., and sent threat letters using their Roman canon law, calling the appellant their slave and threatening to engage in the theft of the appellant's land. On or about 13/22/2021, 13 June 2022, the appellant served a notice of demand on Catherine Phillips by registered mail, Jennifer Finoglio by registered mail, Clayton Clavey Riddle by registered mail, and Kim Jones by registered mail. True copy of proof of service is attached here too, all of which is incorporated herein by reference in its entirety, and it's the pages where it can be found, saying the appellant failed to be their Roman canon law Sesticade trust, but was a living man, and explaining the felonies they were engaging in with a copy of their threat letter enslaving the appellant under their Roman canon law. The Popes owned and operated private bar guild, and the Pope's clergy in the 97th District Court issued a fake judgment to steal the appellant's land. The Pope's owned and operated private bar guild and conspiracy of the appellees were selling the appellant's land in a tax sale without payment of their extortion. Because the Pope's Federal Bureau of Investigation refused to investigate the felonies and the Pope's County Montag land thieves in August 2024, the appellant filed a lawsuit in the lower court. On 7 September 2024, the appellant took this matter to a common law jury as evidenced by the finding of facts and conclusions, all of which is incorporated herein by reference in its entirety. Therefore, this matter is res judicata by the Superior Common Law Court. The Pope's lower court clergy conspired with the appellees to assault the appellant with their canon law minor estate to steal the land. The appellant filed a notice of constitutional challenge, document 108, on 10 March 2025. The appellant filed document 12, mandatory notice, judicial notice of 12 presumptions, and document 113, affidavit of life, and document 114, notice of void judgment. On 18th of June, certified copies of each of which are attached to the appendix, all of which is incorporated herein by reference in its entirety. The bar, the 1871 argument summary, municipal corporation, the minor estate are all unconstitutional because they all come from the Pope. And Article 1 an amendment, Congress says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The minor estate and the ruling of the lower court's clergy is a bill of pains and penalties and unconstitutional under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. All officers of the court have an oath of office to the appellant as evidenced herein by the statement of original standus filed on the corporate denial affidavit, which is recorded with the Pinal County Recorder at fee number 2013-032373, and a pedigree charts that are attached thereto that is now unrebutted truth and public policy, a true copy of which may be viewed at their website. Will Livingston ratified this Constitution for the United States of America on behalf of New Jersey, 1787, is the appellant's fourth great uncle, which means the appellant is posterity as found in the preamble. And the appellant's entitled right of blood, and right of blood cannot be destroyed by any civil law because all the laws of Congress and all the laws of Texas are civil laws. And this court is operating under power which is derived from the appellant as posterity, and the maxim says the power which is derived cannot be greater than that from which it is derived. That's Bouvier's Law Dictionary, 1856 edition. Therefore, it's impossible for the appellant to give any of the Pope's appellees or their private bar guild handlers or this court any authority over the appellant. And the Legislative Supreme Court of the United States agreed and said it's impossible to confer a sovereignty which will extend over the appellant. And that's McCullough versus Maryland. Sovereignty of state extends to everything which exists by its own authority or it's introduced by its permission, but does it extend to those means which are employed by Congress to carry into execution powers conferred on that body by the people of the United States? We think it demonstrable that it does not. Those powers were not given by the people of a single state. They are given by the people of the United States to a government whose laws made in pursuance of the Constitution are declared to be supreme. Consequently, the people of a single state cannot confer sovereignty which will extend over them. The appellant is exempt from the Pope's appellees and the Pope's private bar guild, not because of any formal conception or obsolete theory, but on the logical and practical ground there can be no legal right as against the authority that makes the law on which the right depends. And the appellant requires this court to regulate their property under Article 4, Section 3, Clause 2, The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States, which is the supreme law of the land, anything in the constitutional laws of any state to the contrary notwithstanding. So we'll keep moving here. That's Article 6, Clause 2, Constitution of the United States of America, and we the people fail to be U.S. citizens because the Pope's 14th Amendment, U.S. citizen, failed to exist when the Constitution was written. The term citizen of the United States must be understood to intend those who were citizens of a state as such after the Union had commenced, and the several states that assumed their sovereignties. Before this period, there was no citizen of the United States. The Pope's 14th Amendment, U.S. citizens, a fiction of law. It might be correctly said there is no such thing as a citizen of the United States. A citizen in any one of the states of the Union is held to be called a citizen of the United States, although technically and abstractly there is no such thing. And then Public Law 100-418, August 23rd, 1988. Definitions as used in this section. The term United States business means a United States citizen, so it's a corporation. It's a minor state, is what it is. The Pope's 14th Amendment, U.S. citizen, was created by the Pope's canon law by what is now the Pope's owned and operated Congress. 14th Amendment referred to slavery. Consequently, the only persons embraced by its provisions for which Congress is authorized to legislate in the matter were those then in slavery. The term resident and citizen of the United States as distinguished from a citizen of one of the several states, in that the former is a special class of citizen created by Congress. All citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, convey real and personal property. And that's current law, 42 U.S.C. 1982. Fictions of law were invented by the Roman praetors under canon Roman law for the Pope's ecclesiastical city-states, that is now the Vatican, under the pretense of doing equity. And this is Bouvier's Law Dictionary, 1856 edition, page 520. And it says that fictions of law owe their origins to the legislative usurpations of the bench, which means the fake judge is a legislator when dealing with fictions of law, which means the fake judge's legislative act is a bill of attainder, because a bill of attainder is a legislative act that applied to named individuals to inflict punishment without a judicial trial. That's exactly what they did to me. Bill of attainder means legislative act, no matter what their form, that apply either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. A bill of pains and penalties is a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. Bill of pains and penalties are included in the U.S. Constitution ban on bills of attainder. That's Black's Law Dictionary, 8th edition, which was brought up in the lower court in the demand for relief and document, and in ROA the documents. True copies are which are in the appendix, because judges only hold office during good behavior. Judge, both the Supreme and Inferior Court, shall hold their offices during good behavior. Judges in bad behavior engaged in fraud upon the court. Fraud upon the court is fraud which is directed at the judicial machinery itself, and not fraud between the parties or fraudulent documents, false statements, or perjury. It's where the court or a member is corrupted or influence is attempted, or where the judge has not performed his judicial function. In other words, where impartial functions of the court have been directly corrupted. Therefore, the judges in the lower court are the Pope's clergy, and engaged in fraud upon the court in conspiracy with the Pope's private bar guild members working for the Pope's County of Montague Corporation, when they issued a bill of pains and penalties against the appellant, the named individual, because they intended to be accomplices to the theft of the appellant's land by using the Pope's owned and operated fiction of law minor estate cestui usufruct. The Pope's County of Montague Corporation rendered by force the appellant's land, even though the Texas tax code originating after the Civil War with an act defining what money and property is subject to taxation or exemption and the mode of listing the same on August 21st, 1876. And it says, being enacted by the legislature of the state of Texas that all real and personal property in the state, the property of corporations now existing or may hereafter created, and the property of all banking companies now existing and may be hereafter created, and all bankers, except such as hereafter expressly exempted, is subject to taxation, and such property of the value of shall be entered in the list of taxable property for that person in a manner prescribed by this act, which is for corporate-owned property, in Section 4, the term person, whenever it's used in this act or any other act regulating the assessment and collection of taxes, shall be construed to include firm, company, or corporation, and requires cash or its equivalent for their taxes, which means Federal Reserve notes, as found in Section 104 definitions, as explained in the Catherine Phillips Notice and Demand, and where it's found in the Record on Appeal that was served on the appellees that shows taxable land is used for the production of income. Rendition generally, except as provided in Chapter 24, a person shall render for taxation all tangible personal property used for the production of income that the person owns or the person manages or controls as a fiduciary on January 1st. The rendition originated with Section 7 in the Act of the Legislature, 1876. Section 7, all property shall be listed or rendered in the manner following. First, every person of full age and sound mind being a resident of this state, which is corporate property, which means the appellant's land fails to qualify for rendition, as explained in the notice of demand that was served on the appellees, because income is corporate profits. And this is Eisner versus McComber, and it's got bold and underlining, and the bold and underlining is in the original. That's the only case I've ever seen where they did that, and it was in the original. Becomes essential to distinguish between what is and what is not income, according to the truth and substance without regard to form. Congress cannot, by any definition it may adopt, conclude the matter, since it cannot, by legislation, alter the Constitution from which it derives its power to legislate, and from which within those limitations alone that power can be lawfully exercised. Income is derived from capital, the gain derived from capital. Here we have the essential matter, not a gain accruing to capital, not a growth or increment in value in the investment, but a gain, a profit, something exchangeable value severed from the capital, however invested or employed, and coming in, being derived, which is received or drawn by the recipient for his separate use, benefit, and disposal. That is the income derived from property. Nothing else answers the description. The Pope's bar is an acronym and stands for British Accredited Regency. The Regency is the office or jurisdiction of a region or body of regents, a government or authority by regents during the period during which a region or body of regents governs. Because the Pope's private bar guild members are appointed by Inns of Court. Inns of Court are certain private unincorporated associations in the nature of collegiate houses located in London and vested with the exclusive privilege of calling men to the bar. And that's Black's Law Dictionary, 5th edition, page 709. Which is located in the Pope's dependent city-state, located in the city of London, originally called the Kingdoms of England and Ireland, now called the United Kingdom and the Crown since concessions of England to the Pope, 1213. We will establish a perpetual obligation, and a concession will establish that from the proper and special revenues or our aforesaid kingdoms, for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the Feast of St. Michael 500 marks, and at Easter 500 marks, 700 namely for the Kingdom of England, and 300 for the Kingdom of Ireland. But because King John gave the Kingdom of England and Ireland to the Pope and agreed to rent them back for 1,000 marks sterling per year. And this is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of Pope. and not long after this by a general excommunication of the king and people for several years because they would not suffer an archbishop to be imposed upon them. King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks, which means all private bar guild members are foreign agents of the Pope, which is why they're here under the Pope's Civil Laws of Congress, foundation of the Federal Bar Association, under the Code of Law for the District of Columbia, also now known as Title 35, USC 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945. Both judges in the lower court are the Pope's clergy, private bar guild members as required by the Pope's Civil Laws of Congress, called Code of Law for the District of Columbia, now known as Title 28, U.S. Code Section 631. No individual may be appointed or reappointed to serve as a magistrate judge under this chapter unless he's been at least 5 years a member in good standing of the bar of the highest court of the state. The Pope's dependent city-state, and in the city of London, called the Crown, created the Cestui Act of 1666. Yet still it was found difficult to set bounds to ecclesiastical ingenuity, that means papal immunity. For when they were driven out of all their former holds, they devised a new method of conveyance by which lands were granted not to themselves directly, but to nominal fiefs, to the use of the religious houses, that's the Vatican, thus distinguishing between the possession and the use, and that means usufruct, and receiving the actual profits while the season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of the clergy, that's the Pope, to be bound in conscience to account to a cestui use for the rents and emoluments of the state. Isn't that convenient? The Pope gets to decide whether it's law or not. How convenient. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. Who was held by the courts of equity, then under the direction of the clergy, the Pope, to be bound in conscience to account to a cestui use for the rents and emoluments of the estate, which is under the direction of the Pope's clergy in this case, which is what the Pope's County of Montague land thieves and the Pope's private bar guild handlers did to the appellant, which is what precipitated the War of Independence, as evidenced by the causes and necessity for taking up arms issued by the Continental Congress in 1775. Statutes have been passed extending the courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, and instead thereof to publish and order the use and exercise of the law martial. And for altering fundamentally the form of government established by charter, we saw a misery to which such despotism would reduce us. And that's cause necessities for taking up arms, 1775. And the organic law, the Declaration of Independence, shows it was listed as reason for the Declaration of Independence from the Pope's tyrant, the Crown of England. He's combined with others to subject us, he's combined with others to subject us to a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses, for imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, altering fundamentally the forms of our governments. He's abdicated government here by declaring us out of his protection and waging war against us. Because when they say he is combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, is talking about the Pope's Roman canon ecclesiastical law, which is also why thousands of people were fleeing Europe at that time because of the Pope's tyranny there. Tyranny is the exercise of power beyond right, which nobody can have a right to. And this is making use of the power anyone has in his hands, not for the good of those who are under it, but for his own private, separate advantage. When the governor, however entitled, makes not the law but his will the rule, and his commands and actions are not directed to the preservation of the properties of his people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion, 'Tis a mistake to think this fault only on monarchies. Other forms of government are liable to it as well as that. For wherever the power that is put in any hands for the government of the people, the preservation of their properties is applied to other ends and made use of to impoverish, harass, and subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. And that's John Locke. That's what the Founding Fathers were reading. Two Treatises of Government, Book 2, Chapter 18, Section 199 and 201. With the Spanish Inquisition, I'm sure everybody's heard of the Spanish Inquisition. Inquisition is one way of proceeding in ecclesiastical courts. And other inquisitions and oppressions, the use of information has a long history. For example, in the reign of Henry VII, a very oppressive use was made of them for something more than a century, so as to continually harass and shamefully enrich the Pope's crown. And that's found on Blackstone's commentaries. Courts ecclesiastical are those courts held by the king's authority as the supreme governor of the church for matters which chiefly concern religion and the laws and constitution whereby the Church of England is governed. Much oppression having been exercised through the channel of these courts on persons charged with trifling offenses within their spiritual jurisdiction. And that's Tomlin's Law Dictionary, 1835 edition, Volume 1. Which is why the appellant's ancestors made the first article in amendment: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. After the War of Independence, the Pope's canon Roman ecclesiastical law was brought into America, first with the Pope's 1871 Municipal Corporation at 16 Stat 419. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law. That's Black's Law Dictionary, 4th edition. And then with the Code of Law for the District of Columbia in 1901, Chapter 854, an act to establish a Code of Law for the District of Columbia, the legal estate to be in necessity use. The Pope's minor cestui usufruct is now codified at 31 CFR 363.6 and are unconstitutional because municipal law was the laws of the municipia, or dependent papal ecclesiastical city-states. Encyclopedia Britannica, 1771, Volume 2, page 883. Civil or municipal law is that which every sovereign kingdom or state has appropriated to itself. The appellation municipal was originally confined to the laws of the municipia, or dependent states. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, between Tuscany, Modena, and Lombardy on the northwest and Naples on the southeast. Area 17,822 square miles, population in 1833. 2,742,000. Capital is Rome, population 153,000. Government and elective monarchy, the Pope for the time being the absolute sovereign, with the consulting assembly of cardinals. And that's taken from Watterson, Encyclopedia of Commerce and Mercantile Law, 1863, page 582. Rome, the capital of the Pope's territories and of Italy, anciently the Milrus of the Roman Empire. And that's Encyclopedia Britannica, 1773, volume 3, page 632. And Roman law is also called canon law. The civil or Roman and canon law, though they are not perhaps to be deemed proper parts of our written law, have undoubtedly had a greatest influence in Scotland. The power exercised by our sovereigns and judges have been justified upon no other ground but that they were conformable to the civil or canon laws. The Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in 1870. The formerly Republican leader in southern Italy, Giuseppe Garibaldi, made common cause with the House of Savoy to overthrow the Kingdom of the Two Sicilies, and the people voted in a plebiscite to join Sardinia and formed the Kingdom of Italy in 1861. The Papal States and the city of Rome were annexed to the kingdom in 1870, completing the unification of Italy. This kingdom lasted until the aftermath of World War II, when the 1946 Italian institutional referendum ended the monarchy, and are now called Vatican City and the Holy See, and it continues to this day. The sovereignty and exclusive jurisdiction over the Vatican City, which Italy recognizes as pertaining to the Holy City, forbid any intervention therein on the part of the Italian government, or that any authority other than that of the Holy See shall be there acknowledged. And that's the Lateran Pact, Article 4, 1929, and is unconstitutional because of Article 1 and Amendment. Congress shall make no law respecting an establishment of religion. And the Pope's necromancy, sestike usufruct, which is now called the minor estate, is an entity because an entity includes the estate of a living person, such as an incompetent or a minor. That's 31 CFR 363.6. And a minor can be anyone over the age of 18 who has failed to take control of the securities in the Treasury direct account. The term is also used to refer to an individual who has attained the age of 18 years but has not yet taken control of the securities contained in his or her account. The Pope's sestike minor estate, is a fiction of law which is invented by the Roman praetors under the pretense of doing equity, and owe their origin to the legislative usurpations of the bench. And that's Black's Law Dictionary, that's Bouvier's Law Dictionary, 1856 edition, page 520. And the Pope's fictions of law and necromancy are satanic. Deuteronomy 18, 10 to 12. There shall not be found among you anyone that maketh his son or his daughter to pass through the fire, or that useth divination, or an observer of times, or an enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all that do these things are an abomination unto the Lord, and because of these abominations the Lord thy God doth drive them out from before thee. And puts you under the Commerce Clause, Article 1, Section 8, Clause 3, violating Article 1, Section 8, Clause 17, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may by cession of particular states and acceptance of Congress become the seat of government of the United States. To use fraud and deception to assault people with a quasi-contract, a fake contract, a subset in its origin an action of tort, a subset was soon transferred into an action of contract, becoming afterwards a remedy where there was neither tort nor contract, based at first only upon an express promise. It was afterwards supported upon an implied promise and even upon a fictitious promise, and competed with equity in the case of essentially equitable quasi-contracts. Remember, it's under the pretense of doing equity. Both the Roman and English law, there are certain obligations which were not in truth contractual, but what the law treats as if they were. They were contractual in law, but not in fact, being the subject matter of this fictitious extension of the spirit of contract to cover definitions which in reality do not fall within it, which requires the Pope's fiction of law minor estate. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. Because under the Commerce Clause, the boundaries of the Pope's District of Columbia, and through their plenary power nationally, covers those citizens, even one of the several states, as though the district expands for the purpose of regulating the citizens wherever they go throughout the states of the Union. National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, which is why the Kavanaugh hearings, when he was interviewed for a Supreme Court appointment, they asked him, can we go after a U.S. citizen in Afghanistan? And he said, yes, you can. And because plenary power is a dictatorship under the Pope's canon law, plenary jurisdiction accords full and absolute power of the subject matter on the parties in a case. Plenary is full complete in the courts of admiralty and the English ecclesiastical courts, causes, and suits in respect of different courts of proceedings. In each are termed plenary or summary. Black's Law Dictionary, 3rd revision, 8th edition, volume 2. Plenary, a plenary power or plenary authority is a complete and absolute power to take action on a particular issue with no limitations. It's derived from the Latin term plenus. Plenary power, complete power over a particular area with no limitations. So Latin term plenus, okay, so that brings in the Vatican, the Pope. The term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. The judges in the lower courts are tyrants operating as bought and paid for administrative clerks, masquerading as judges. The Pope's clergy, under the Pope's canon law of trusts and bad behavior and fraud upon the court, which are non-judicial proceedings, because whenever a statute's involved, the Pope's fake judge is actually a court masquerading as a judge, as the Pope's clergy. When acting to enforce a statute and subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer, not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule not only in the state courts but of the federal courts as well that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial clerk for an agency. Judges have become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency, which means they were legislators engaged in legislative acts against the appellant. A named individual, which is a bill of attainder or a bill of pains and penalties, which are prohibited under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. And also Article 1, an amendment, which says Congress shall make no law respecting an establishment of religion, because it's from the Pope's Roman law, also known as canon law, and because they've imposed martial law rule, which is why we took up arms in 1775. Statutes have been passed, we already read this one, and more recently with the bankruptcy emergency. It's an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress, in session, June 5, 1933, joint resolution to suspend the gold standard and abrogate the gold clause, dissolve the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments, and as further evidence that the United States federal government exists today in name only. And that's Congressional Record, March 17, 1993, Volume 33. Since March 9th, notice the date. Let me look at YouTube real quick. Excuse me.
Our favorite.
Sorry?
It's our favorite. That's when they changed everything. The Great Bankruptcy.
The what?
Well, they say that's when they converted us. They made the birth certificate.
Yeah, well, that's all tied in. So it's March 9th. Notice the date. Since March 9th, 1933, the United States has been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways control the lives of all American citizens. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. Martial law rule is the law of emergency and necessity. This is Ex parte Milligan. There's three kinds of martial law. Full martial law is when actually invaded by a foreign enemy or insurrection. Troops are put on the streets. Martial law proper is the law of the armed forces. When a sergeant tells a private what to do, it's enforced by court-martial. Martial law rule is the law of emergency or necessity. Used during peace times, can go on indefinitely. And that's ex parte Milligan, cited in Diet versus Turner, and the non-ratification of the 14th Amendment by Judge H. Ellett of the Utah Supreme Court. The Pope's private bar guild members on the bench will tell you I can do anything I want. This is a war over the intrusion of the civil law upon the common law. The court in Diamond v. Harris calls the civil law superior equity. It's difficult to see how the courts of the state are to ignore the common law as a rule of decision when it's made so by statute and adopt the civil law, even though it had the merit of superior equity. And that's the Diamond v. Harris case. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. This is exactly what happens when martial law is imposed. If equity is the law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. And again, that's the non-ratification of the 14th Amendment by Judge H. Ellett of the Utah Supreme Court in the case Diet versus Turner. Because normally, equity follows common law, which is taken from the Holy Bible. But under martial law rule, there is no common law, which is also talked about in the Causes and Necessities for Taking Up Arms, 1775. Already cited. Every system of law known to civilized society generated from or had as its components one of three well-known systems of ethics: pagan, Stoic, or Christian. The common law draws its subsistence from the latter. Its roots go deep into that system. The Christian concept of right and wrong and justice motivates every rule of equity. It is the guide by which we dissolve domestic frictions and the rule by which all legal controversies are settled. And that's Strauss versus Strauss. It's obviously a divorce case, which makes it satanic. And the Pope's private bar guild Satanists are using the Pope's canon law of capitis diminutio maxima, loss of status through the use of capitalization, the highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away with it all rights of citizenship and all family rights. It's Black's 4th edition. Under the Commerce Clause, Article 1, Section A, Clause 3, to assault people with their penal action for breach of quasi-contract. Penal action is an action on a penal statute, an action for recovery of penalty given by statute, where an action is founded entirely upon a statute, and the only object of it is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty, in their strict primary sense, denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense against its laws. Notice pecuniary. Keep that in mind. We're going to talk about that in a minute. The words, so there's pecuniary or corporal. The noun penalty is defined forfeiture to be forfeited for non-compliance with an agreement. The words forfeit and penalty are substantially synonymous when it's all tied to the Pope's canon law with their contract pecuniary cause. Pecuniary cause, such as arise either from the withholding of ecclesiastical dues or the doing or neglecting some act relating to the church whereby some damage accrues to the plaintiff towards obtaining satisfaction for which he's permitted to institute a suit in the spiritual court. Such, for instance, are the subtracting and withholding of tithes from the parson or vicar, the non-payment of ecclesiastical dues to the clergy, as pensions, mortuaries, compositions, and the like. And that's citing Blackstone's Commentaries, Book 3, and is cited in Holt House and New Lock Dictionary, 1850 edition. to populate the Pope's prisons by selling people into slavery. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state. And Trump even paid off the Pope when he commuted Roger Stone's penance. Well, I meant sentence. No, I meant penance, which was changed into a sum of money to be applied for pious uses, which is usufruct. Penitentiary meant a penitent or the ordainer of penitence, a place of penitence. Anderson Law Dictionary, 1889 edition, page 764. Penance is a punishment imposed for a crime by the ecclesiastical laws. Okay, so if you're in a penitentiary, it's the Vatican. You're in prison, it's the Vatican. It's an acknowledgement of the offense. Penance may be changed into a sum of money to be applied to pious uses called commuting. And that's found in Book 3 and Book 4 of the Institutes and the Laws of England by Coke, and also, that's Jacob A. New Law Dictionary. And because of the administrative proceedings under the Pope's canon law, there are more people in prison in America as a percentage of the population than there are in communist China or the Soviet Union, or the worst dictatorship in history. And if there were Christians here, the Pope's private bar guild Satanists selling people in slavery would get their necks stretched. Because in Deuteronomy 24:7 it says, if a man be found stealing any of his brethren of the children of Israel, and maketh merchandise of him or selleth him, then that thief shall die. Thou shalt put evil away from among you. And the Innocence Project estimates that 60% of prisoners are innocent. But it's such good business for the Pope and their canon law so-called courts, which is one of the grievances in the organic law of the Declaration of Independence. He's plundered our seas, ravaged our coast, burned our towns, and destroyed the lives of our people, all of which has been planned and orchestrated by the Pope. Within 20 years, this country is going to rule the world. Kings and emperors will soon pass away, and the democracy of the United States will take their place. When the United States rules the world, the Catholic Church will rule the world. And Roman Catholic Archbishop James E. Quigley, Chicago Daily Tribune, March 5, 1903. The Pope now owns and operates the bankrupt 1871 corporation, as evidenced by the Roman Achaia military staff that's planted on all conquered nations and is sitting on the right side of the speaker's podium, and the two Roman fascia, bundle of rods bound into weapons, symbolizing the under the rule of a single man, that are on the wall on each side of the speaker's podium in the U.S. House of Representatives, which is also why, as Speaker of the U.S. House of Representatives, Nancy Pelosi told the members, we can't read this bill until after we pass it, because she was taking instructions from her Jesuit handlers. And there's a picture of the speaker's podium, and you see this right here is pointing at that Roman Achaia military staff and the two Roman fascia here. All of which evidences the fact that the 1871 corporation, that's 16 Stat 419, currently operating in the District of Columbia, is the Pope's dependent city-state. And the Vatican's Pope Francis recently issued an apostolic letter about jurisdiction of judicial authorities of Vatican city-state in criminal matters that talks about concurrent jurisdiction in other states, which means other papal states, like the District of Columbia and the City of London, United Kingdom Crown. And here's where it talks about it. When the same matters are prosecuted in other states, the provisions in force in Vatican city-state on concurrent jurisdiction shall apply. And that's apostolic letter issued motu proprio, entering into force on 1st September 2013. Which means the Pope's ecclesiastical canon law is brought into Texas with the Commerce Clause, Article 1, Section 8, Clause 3. And the Vatican's Pope Francis came and addressed his own and operated Congress in 24 September 2015, and the Pope's satanic private bar guild members are assaulting people like the appellant and their Roman fiction of law, with their Roman fiction of law, minor states, sestike use, usufruct, trust, necromancy with the presumption of jurisdiction, presumptions of the office of trustee because of the sestike usufruct, minor estate, and presumptions of suretyship. As posterity, the appellants entitled to common law, not canon Roman law, by right of blood, as described in Article 6, Clause 2 of this Constitution for the United States of America. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under authority of the United States shall be the supreme law of the land, and judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. And also is found in the Judiciary Act, saving to suitors in all cases the right to a common law remedy, where common law is competent to give it, shall also have exclusive original jurisdiction, cognizance of all seizures on land and other waters than as aforesaid made, and all suits for penalties and forfeitures incurred under the laws of the United States. That's 1 Stat 77, Section 9A, and the Judicial Code of 1911. The right third of all causes in admiralty, maritime jurisdiction, saving to suitors in all cases the right of a common law remedy, where the common law is competent to give it. That's 36 Stat 1161, Section 256, Part 3. Because the law of the land is a phrase convertible with the phrase common law, the principle that no person should be deprived of life, liberty, or property except by due process of law did not originate with the American system of constitutional law, but was contained in the Magna Carta, sometimes referred to as Chapter 29, confirmed on the 19th day of June, 1215. No freeman shall be taken or imprisoned or seized or outlawed or exiled or any way destroyed, nor we go upon him nor send upon him except by the lawful judgment of his peers or the law of the land. It's even been said that the principle was known before Magna Carta and that it was originally designed to secure the subject against arbitrary action of the Crown and to place him under the protection of the law. It is settled beyond question that this principle came from England to America as part of the common law and has been a fundamental rule in the common law. When first adopted in the Magna Carta, the phrase law of the land had reference to the common law and has been a fundamental rule in common law. And that's Book 16, American Jurisprudence, 2D, Constitutional Law, Section 543. And common law and law of the land has always been here, long before the government was here. The individual may stand upon his constitutional rights as a citizen. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are refusal to incriminate himself and the immunity of himself and his property from arrest or seizure, except under a warrant of the law. He owes nothing to the public so long as he does not trespass upon their rights. Long antecedent means long before the organization of the state. And because the Pope's maritime codes only apply to the high seas up to the high water mark or the first bridge on any navigable river, and the District of Columbia or any federal enclave as found in Article 1, Section 8, Clause 17 and 18. The appellant has been very vociferous about being posterity as found in the preamble, and a living man and a living soul, and every document filed into the case evidencing the prejudgment on behalf of the Pope's private bar guild members on the bench, the Pope's clergy, and their Vatican handlers. Because it fails to matter what the appellant says or does, this case was prejudged from the beginning using trust law by the Pope's clergy. The appellant demanded the Pope's County of Montague produce a bona fide contract or be guilty of felonies in the Catherine Phillips Notice and Demand, a true copy of which is in the appendix, and they failed to produce any evidence of a bona fide contract, and the Pope's clergy in the lower court failed to produce a contract. It's impossible to prove jurisdiction exists absent substantial nexus with the state, such as a voluntary subscription to a license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. This court is required to presume that no contract exists. If the record does not show upon its face the facts necessary to give jurisdiction, they will be presumed not to have existed. The law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. The Pope's clergy in the lower court failed to be an Article 3 court because the appellees in this matter are all Pope's U.S. citizens, and only an Article 3 court can decide matters involving life, liberty, or property. Justice Thomas, constitutionally conforming agency adjudication, cases involving deprivation or transfers of life, liberty, or property constitute a core cases that must be resolved by Article 3 courts, not executive administrators dressed up as courts. Where a controversy is of such a character as to require the exercise of judicial power defined by Article 3, jurisdiction thereof can be conferred only on courts established in virtue of that article, and Congress is without power to vest that judicial power in any other judicial tribunal, or of course in an executive officer, administrative, or executive board, since they're incapable of receiving it. Therefore, they're acting with no authority and maliciously. Although probable cause may be inferred without malice, malice may be inferred from lack of probable cause. The Pope's clergy have ceased to represent the government. An officer who acts in violation of the Constitution ceases to represent the government. The Pope's clergy are deemed to know the law with no immunity. The officers of the court have no immunity when violating a constitutional right, for they're deemed to know the law. Judge loses absolute immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act that's not judicial in nature. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. The Pope's clergy's bill of pains and penalties are unconstitutional acts and a nullity. An unconstitutional act is not law, it confers no rights, it imposes no duties, affords no protection, it creates no office, it's in legal contemplation, as inoperative as though it had never been passed. An unconstitutional law is void and is as no law. The offense created by it is not a crime, and no one is bound to obey an unconstitutional law, and no courts are bound to enforce it. The Pope's clergy held a kangaroo court. Kangaroo court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the bias of the court or other tribunal. And everything the Pope's clergy did is a fraud and a nullity. Once a fraud, always a fraud. Things invalid from the beginning cannot be made valid by subsequent act. A thing void in the beginning does not become void, and by lapse of time. Time cannot render valid an act void in its origin. Out of fraud, no action arises. And any act to conceal a fraud becomes an act of fraud. And fraud is inexcusable and unpardonable, and any fraud amounts to injustice. And the Pope's bill of pains and penalties, fake judgment, is brutum fulmen. And the Pope's bill of pains and penalties, judgment, is void and an absolute nullity. The Pope's clergy unfiled 78 criminal complaints that the appellant filed into the case in support of the Pope's Federal Bureau of Investigation, refusal to investigate them in support of targeted justice agenda and weaponized Department of Justice, to refuse to investigate felonies against targeted individuals like the appellant, in the hope that the appellant will exercise his right to resist their unlawful arrest and their unlawful theft of the appellant's land with lethal force if necessary, U.S. versus Schooner Amistad, so they'll have an excuse to murder the appellant and say they killed another sovereign citizen terrorist for their communist handlers, and in support of their war crimes agenda to take reprisals against anyone who thinks they have rights for their political beliefs, and their communist handlers to eliminate private property rights, all of which is in support of the Pope's private bar guild and their Vatican handlers who love satanic blood sacrifice to the Roman cult god Baal, so they can pillage the fake money from the Treasury direct account under a GlennWinningham fern in all block capital letters, under the Hague Convention concerning the international administration of the estates of deceased persons, concluded 2nd of October 1973. And the appellant's not suicidal, but if the appellant does turn up dead, this is deathbed testimony. The Pope's clergy are priests of Baal and evidently intend to perjure their oaths of office to the supreme law of the land under the Pope's Code of Law for the District of Columbia, now known as United States Code 28 U.S.C. Section 453. And the God that they're talking about in their oath is Satan. They have absolutely no intention of being neutral or unbiased. but prejudged this case from the beginning to bring District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17 for their Vatican handlers, Sestike Usufruct Minor Estate. And it failed to matter what the appellant said or did because the Pope's clergy intended to sell the appellant into slavery from the beginning in support of their Vatican handlers and the Pope's County of Montague private bar guild buddies, because their oath to their private bar guild is also to their god Satan, who is the father of all lies. The Pope's clergy are engaged in treason and violation of the Pope's Code of Law for the District of Columbia, Title 18, USC, Section 2381. And since we were attacked in 2020 with a stolen election, a fake pandemic, fake vaccinations, forced medical experiments by the Communist Chinese, the Venezuelans, the Cubans, the Vatican, the Serbians, and others, the appellees are giving aid and comfort to the communist enemies in a time of war. Because the first plank of the Communist Manifesto is the abolition of private property rights, and the Pope's clergy are busy helping the Pope's County of Montague corporate land thieves in the theft of the appellant's land. The appellant has filed bar grievances against 98 of the Pope's private bar guild clergy, some more than once, and they've all been dismissed as an inquiry. They were all appealed to the Pope's Board of Disciplinary Appeals, and they were dismissed again. The appellant has filed judicial complaints against more than 50 of the Pope's clergy and the State Commission on Judicial Conduct, some more than once, and they've all been dismissed, 25 of them on the same day. The 1871 Municipal Corporation at 16 Stat 419 that is now operating in the District of Columbia is unconstitutional, so this is the conclusion. Because the municipal law is Roman law, which is also called canon law, and is ecclesiastical from what is now the Vatican, and Article 1 and Amendment says Congress shall make no law respecting an establishment of religion. The minor estate and the Pope's Municipal Corporation, County of Montague, in conspiracy with the Pope's private bar guild and the Pope's State Bar of Texas are assaulting the appellant with is unconstitutional because Article 1 and Amendment says Congress shall make no law respecting an establishment of religion. The Pope's State Bar of Texas, its parent corporation, National Bar Foundation, are unconstitutional because they're owned and operated by the Pope, and all bar members are foreign agents of the Pope as clergy, busy assaulting the appellant with their Pope's Roman law / canon law and ecclesiastical law, which is unconstitutional because Article 1 and Amendment says Congress shall make no law respecting an establishment of religion. The judgment of an order of the Pope's lower court clergy is a bill of pains and penalties because it's a legislative act that punishes the appellant with the theft of his land without a judicial trial, and the judgment and order of the Pope's clergy and the 97th District Court is also a bill of pains and penalties, which are unconstitutional under Article 1, Section 9, Clause 3, and Article 1, Section 10, Clause 1. The appellant requires an order vacating the void judgment of the Pope's lower court clergy, an order to the Pope's Federal Bureau of Investigation to investigate the felonies of the County of Montague corporate thieves, and an order that the Pope's United States Attorney prosecute the felonies. The appellant requires an order declaring the 1871 Municipal Corporations unconstitutional, and the minor estate, National Bar Foundation, and the State Bar of Texas are all unconstitutional. The appellant requires an order dissolving and liquidating the Pope's minor estate, and the appellant fails to care what they do with the fake money in the Treasury direct account. They can put it up their rectal orifice. But the appellant wants it dissolved and liquidated yesterday. It's a fraud, a lie, necromancy, and satanic, and is being used to enslave the appellant. Signed and sealed in red ink on the land under penalties of perjury without the Pope's United States. And that's it. Non-domestic mail without the Pope's United States. I'm putting that on all my stuff. This is a certificate of service, so that's easily within 30 pages. This is the certificate of service, and I actually I forgot to put something in here. See, I said I filed this appeals brief, but I didn't say anything about the certificate of service. So I had to I sent another one with the appeal brief that talked about it for the certificate of service. Anyways, yeah, the clerk sent it back to me and said that I need to redo it.
Resend it all to the 26 liars?
Sorry?
Resend it all to the 26 liars?
Oh, yeah. Well, I had to send out the appeal brief to them anyways. It cost me $500 to serve it because I had to send it by second day air. And it was going out to, it wasn't 26 liars, but it was 2 copies of everything, 7 copies to the court. It's 2 copies of the appeal brief, 7 copies to the court, and then so that 2 copies to the liars, 7 copies to the court, and there was like 10 liars I had to send it to, and so then the appeal brief was I did that by flat rate box, and so then that cost $20 a piece. So that's still 10 of them. It was over $200 just for the appeal brief, and it was $60 because just for UPS ground for the court, because it was a large box. It was, I don't know what the weight was. It was probably about 60 pounds, I'll bet you. It was seven appeal briefs, and there's 500 pages each one. So
is that the most amount of liars you've ever sued at one time then? I know you said you've dropped 25 in one day, but
that was 25 judicial complaints they dismissed in one day. I like to rub that in because they're being assholes. But I don't keep track of how many liars I send it to. I really don't care. I think that what they do is they go and add themselves unnecessarily. Like there's certain lawyers that are appellate lawyers, right? And so, but all the lawyers I'm sending this stuff to, not all of them. There was actually 2 lawyers that got added in that are appellate lawyers that deal with appeals cases, and then the rest of them is just the same lawyers. And I think that it's unnecessary. I think they're just trying to make it more expensive, and so they're scum. They're just scum.
yeah, that's why they say that court's a rich man's game.
Well, to some extent, I mean, you gotta defend yourself. I mean, they try and make it as expensive as possible because they're scum. They want to violate your rights. They don't want you defending yourself. And so at some point, if we had any Christians in this country, it wouldn't be happening because they'd be getting their necks stretched. Okay, but the people are just a bunch of brain dead fucking idiots. And Judgment Day's coming. I gotta say, Judgment Day's coming. And I'm gonna feel sorry for them, but I won't feel that sorry because Judgment Day's coming, and there's gonna be consequences. Anyways, so that's the end of that.
The Bible says that man will be judged by his deeds. So interpret that any way you want.
Yep, you're right. But there's sins of omission, and there's sins of commission, stuff you do, and there's stuff you fail to do. And the people have been absolutely asleep at the wheel. If there was, like I said, if there was Christians in this country, these fucking bar scum would be getting their necks stretched. And I'm looking forward to seeing that happen. I'm really looking forward to that. There's some bar members I'd like to see dance, but of course, I'd make sure they get due process of law before they get their necks stretched. But anybody that sells people into slavery, and they're all doing it, they just routinely sell people into slavery, and they should get their necks stretched.
Yeah, can we see the reply that one of the lawyers is already, or sorry, liars. Well, excuse me. Oh, jeez. Man. Yeah, one of the liars already replied. You said you got one already.
Well, one of them sent me an email. And
yeah, show and tell.
Sorry?
Show and tell us.
want to see it?
Yes, yes, yes. Yes, I like deciphering language of liars. I mean lawyers, liars. Oh, confused.
It was an attorney general of Texas, an assistant, and here we
How
go.
many seals? How many seals?
Okay, so I'm going to share the screen. So this is an email I got from one lawyer, and
Liar, come on.
he said, I'll be filing 2 motions with the Court of Appeals regarding this cause. Motion to dismiss because it has waived any appellate issues properly before the Court of Appeals. And that's not true, actually. And a motion to stay the briefing deadline of my clients, and the alternative, an extension of the briefing deadline. And I just said I'm opposed to it. And so we'll see. I haven't gotten anything from him. I actually said, I sent him another email after that, and I said, I don't have a problem you getting more time, but other than that, so anyways, so anyways, so that's about it. So I guess you must be recording this, eh?
Yes, we are. Yeah.
Shoot.
No, it just stopped now.
No, I stopped it. I was wanted to stop
Oh,
sharing, and I clicked on the wrong thing. But I was going to end it anyways. We're about done. But
Yeah.
so
Okay.
so that's about it. The That's the appeal. That's the PDF. That's the actual document that I served. The appeal brief. We'll see. I might have my petition for writ of certiorari done by next week. We'll see. But I'm still, there's a lot of stuff I have to do to get that ready. I saw some stuff in this that I need to add in, actually. And right now, see, you're allowed 40 pages when you go to the Supreme Court, for the arguments, and I'm only at like 25 pages, and I don't want to necessarily expand it out any further, but I know I can add in stuff, and I have plenty of room to add stuff in. Matter of fact, I usually do it at space and a half. They're supposed to do double space, and I've always and traditionally done it just space and a half. And but I started double spacing everything because I just it was like 25 pages or 20 pages. And but I see that just from reading this now that there's some things I need to add in, and so we'll see.
Sounds like they're going to squash it, but they're going to drag it out.
I don't know. I have no idea. I find that the Court of Appeals usually tries to accommodate you somehow. It might not be exactly what you want, but I've actually gotten half decent. But I'm already, if I it's going to be months before I get an answer out of them, and so the the only issue is if they do this motion that he was talking about, then I'm going to have to answer that. But beyond that, it'll be months. It'll probably be like it's July. It might be Christmas. It might be next year before I hear. So I'm planning on having this. I told him I was going to do a Rule 11 petition to the Supreme Court. So I don't know. Maybe he's not going to do anything. I don't know. I haven't heard anything from him.
What's going on with the land? Have you got any further tax assessments or bills from it or
Well, they send me
statement?
letters, and I write on the outside, no such thing at this address, and send it back to them.
Good for you. Good for you. Well,
So,
I'm
anyways,
glad that you've updated us on everything because I was curious to know about the Egypt incarcerated gentleman and how he's going to plead out in his situation. And I'm happy to hear what he's doing. I would probably go that same route because he's already been in there for quite some time. So, no, it's very interesting to keep up on what's going on in Texas and what's going on in Glen Fern's mailbox.
yeah, well, it's like about 102 today. It's pretty hot, and it's humid. The humidity is what gets me. If it wasn't for the humidity, it wouldn't be bad. But, anyways, so it's pretty hot here right now. It's
Yeah, you must.
typical weather for this time of year.
Right, right. Like an oven, eh? So you're not going to escape to New Jersey anytime soon and go
Not
and do
gonna
any
what?
more. What about Daniel over on, where's Daniel at? You know, that gentleman who operates that other group. He said that you were going to do,
I
you
haven't
know, the
heard
same.
from him at all. He tried to call me one time, and I couldn't hear him what he was saying. We
Uh
couldn't.
huh.
He tried to call me on Telegram. I don't know why he
Oh,
did that, but he tried to call me on Telegram, and I couldn't hear him, and he didn't call me back. So
yeah, that conference idea that you were talking about with him sounded very interesting.
the Extraordinary Science Conference.
Well, no, you were thinking about doing something on his estate.
Oh yeah, yeah, yeah. Well, he has never gotten back with me, so I haven't bugged him about it. Although there is one group, there's a group in England that's wanting to collaborate with me, and they have some pretty interesting material. They have ways of recouping, they have a way of recouping your mortgage, where you get it all back. Um, and they seem to be having some success. They get it from the treasury. They don't try and get it from the bank. They just get it from the treasury, and so and they have like I watched the video they did um, last Saturday about how to get a diplomatic U.S. passport, and he had applied for it, and he's I don't know if he's ever been here or not, but they live in England, and but he said that there's under their regulations that foreign diplomats, are entitled to a U.S. passport. And so, and he went and prepared the paperwork and took it to the U.S. Embassy, and the clerk got it. And the clerk said, "Well, I got to give this to the expert back there." And so he gave him a few minutes, and then he went up there. And then so he went back to his seat and sat down for a few minutes, and then he came up a few minutes later, and the expert came up and he said, all he wanted to know is, where do you want it sent? And he had to pay for postage to have it sent. That was it. And so then they contacted him after that with some questions, and he went to the U.S. Embassy and answered the questions. And that was 2 weeks ago from when he might have it by now. It's hard to say.
More
Anyways,
diplomatics, the better. More
oh
diplomatics, the better.
yeah, no joke.
Mm-hmm. Did you ever, you know, that earlier on in the week I was asking about the doctrine of the decedent? Have you come across any of that? Because up here in communist world, all that's coming up is the doctrine of death through the church doctrine.
No doubt.
And, and
No doubt.
apparently it was brought into effect when in the Obama era, and the reason why all that was brought into effect is because Obama needed to drop his inheritance to to Michelle, right? And at that time during the church, I know because I was working there, the Pope was ruling on same sex marriages. And it was going to be like the ruling of the church. And I heard about the doctrine of death at that time. And apparently, Obama rewrote it to be the doctrine of the decedent so that he could, make his same sex, so called same sex partner his inheritance partner. Because before that, a woman, or you could not inherit or give your estate to your same sex, partner, right? So that's why all that came into effect. And it was done right through the players of the Pope, right? So it was pretty strong doctrine. So I wanted to know if you were able to find it on your end of the line.
Not surprising. It doesn't surprise me. I haven't paid any attention to that. It's not like it's something that I want to pursue. I want to get that minor estate terminated, and and I don't care what they have to do it. And so, we'll see. But it's a badge of slavery, is what it is. And you're dealing with a bunch of thieves and pirates, and so I want nothing to do with it. You can put it up your rectal orifice. Um, anyways, so
Well, it's buried. It's buried. That's for sure. They don't want us to see it.
Yep.
So, yeah, if I do find it, because apparently it's supposed to be written for every man and woman, not just our sexual preferences.
Yeah, it's nobody's business what you do in your bedroom.
Well, we want to be able to leave our inheritance to whoever we want, and especially to our wives, right? If they're
Well, our
living
family.
in,
Yeah, it should be our family, and if whoever's our family is up to us, well, we decide our family is. I don't have a problem with that. Um, but anyways,
no, but prior to that, the court would always rule in the first males to receive everything before the wife. So that made a lot of issues. Right?
yeah, it wouldn't surprise me.
It pertains to, it's very vast doctrine, so that's just why I've asked about it. But no, I won't keep you anymore. No, I don't have any bad liar jokes for tonight. But
Okay.
last week you're going to be jealous. I was out picking huckleberries.
You went out picking where?
Huckleberries out
Oh,
in
wow.
the forest. Yeah.
Wow, that sounds like
So
fun. That's just a nice
it
family
was.
activity.
It was, but it was hot, and I had my bear spray with me.
Yeah, I'll bet. I'll bet. Yep. All right. Well, I guess we'll see you guys next week. Same time, same place, same channel.
That would be awesome. Give us some more updates, okay?
Okay, you bet.
Okay, so talk to you later,
See
Glenn.
you
Have
next
a good
week.
night.
Good night.
Bye now.
Hello, Nelson.
Hey, Glenn, I'm going to be stopping by in about 10, 20 minutes. Can you open the door when I get there? I'll call you.
Yeah, sure. Yep, no problem. I'm
All right,
still
bye.
here. I haven't left.
All right. Thanks.